In some cases, such as in Argentina, constitutions incorporate some international conventions which themselves proclaim even more rights. Judges swear both to obey and to apply the law. But applying the law is understood to include ensuring that no act enacted by the legislative branch violates any constitutionally enshrined declared rights, even any which may be contained in international conventions. International conventions are founded, as always, on the law of treaties, but once adopted, they tend to be applied, invoking the idea of jus cogens, also to states which did not ratify them. Thus, a modern legal system is thought of as founded primarily on certain rights not necessarily enacted or expressly agreed to by national states. Secondly, by treaties as conformed or interpreted according to those superior rights. Thirdly, by the constitution of a state when it guarantees some rights, provided they are not opposed to higher levels, and rather confirm and express them. Fourthly, by laws or other inferior norms enacted by organs which have been granted the appropriate competence by the Constitution itself or its derived norms. In this intervention, I will clarify the concept of right according to the different shades in which, as a matter of fact, the idea of a right is interpreted. When their scope is very general, those rights are called human rights, and they are included in constitutional texts or in international conventions, and they are imposed even with a retroactive effect by the way of international law. This is not the place to examine the origin or the justification of human rights, but it is still possible to indicate that such model, endowed as it is with great political prestige, overwhelms inferior levels of the normative system and reverses the technical way to propose and describe the law. Such phenomenon is far from new. The 1789 Declaration of the Rights of Man and Citizen set up that method, which was gradually extended to constitutions all over the world. To invoke one of those guarantees was to claim that a state requirement was illegitimate, or to eliminate a limitation imposed by the rules. That way, every obligation established by the law subsisted, with the exception of those in conflict with rights. Eventually, however, rights were extended by successive generations to certain social and economic guarantees. This way, whichever the justification of such rights may be, the rule establishing them does not indicate the concrete actions to be made to reach such states of things. Thus, rights become assimilated to principles, as Alexis says, to optimization commands. But the way to optimize a value remains delegated to other authorities, sometimes the legislative branch, or more frequently, the judiciary. Assuming those conditions, it is useful to examine more precisely the concept of a right from which a duty or a set of duties or their absence has to derive. As a matter of fact, the will to make a certain action effectively accessible by the bearer of the corresponding right admits different degrees of or levels of intensity, and each of those levels can be represented by a different configuration of duties or competences. The first level, the weakest of them all, is represented, as it is known, by negative permission. There is not within a system S a norm forbidding the subject the exercise of the action P. Maybe the legislator has not thought on that subject, but the fact is that she has not acted to prohibit it. In a formula, and always referring to the system S, the first formula of the handout applies. There, S is the normative system of reference, and the prohibition of action P is not a part of it. In the second level, the legislator has considered the matter and deemed it important enough to enact legislation expressly granting citizens the permission to do P. To the subject, the effect in a determined moment is exactly the same as the one of the former level. However, within the dynamic dimension of the normative system, the result is different. Any decision of a delegate authority in order to forbid P has to give way before the permission expressly granted by a superior entity in the legal hierarchy. Not because such decision is itself forbidden or off the limits of the delegate's authority, but by the simple application of the principle lex superior. In static terms, thus, this level of a right may be represented as the second formula of the handout. In the notation, the permission to do P is a part of S. In the third level, even without a superior explicit permission, the legislator wants to prevent a delegate authority to prohibit P. So she forbids such authorities from enacting a norm which includes that prohibition. However, unless P is expressly permitted by the superior, a delegate could challenge the prohibition by forbidding those subjects within its competence from undertaking the action P. Such delegate prohibition would be valid, but the authority enacting it would break a rule and could be punished by its superior for its disobedience. In order to represent the situation in a formula, we must introduce the notion of delegation or authority or normative hierarchy. This will be indicated by the constant H, followed by authority variables, M or N, in decreasing order of hierarchy. So in S, the third formula applies. In words, when a third level right has been established by an authority M, it is forbidden to an inferior authority to prohibit P. In the fourth level or degree, the superior tries to prevent the situation foreseen in the former level. In order to do so, it establishes that the prohibition of P is out of the competence of any of its delegates. So, if a delegate enacts such norm, this rule would remain invalid because of the delegate's incompetence. Whether the delegate is or is not subject to a punishment is irrelevant within this degree of right. Now, it may be so if the prohibition mentioned in the former degree subsists too. But even if the possibility of a norm forbidding P is cancelled, nothing prevents third persons from opposing obstacles to the behavior permitted by the normative system. In S, the fourth formula applies. On these terms, a fourth-degree right established within the normative level M means that for every inferior authority, N, the prohibition of P by it does not become a part of S. In the fifth degree, the fact that P is permitted and cannot be forbidden is not enough for the legislature. She insists that the subject willing to do P shall not be prevented from it by third persons. So she enacts a norm forbidding everyone to interfere with the citizen who performs the action P. To represent this situation requires the logic of action as proposed by von Wright. So in S, the fifth formula applies. In other terms, it is forbidden for anyone to prevent any other person, the bearer of the right, from performing P. In the sixth and last level, the legislator acknowledges that even if nobody opposes an obstacle to P, some willing persons are not individually able to perform such behavior. In order to solve this last difficulty, the legislator establishes an obligation for every subject, or for some of them in a certain favorable situation, or even for a delegate authority, of giving an effective help to any person willing to perform P, but finding some obstacle to do so. In formula, the sixth formula of the handout. So there is at least a subject X who is obliged to help Y to perform the action P. Here, the link of the formula with the concept is approximate, because to introduce the variables as variables, the will of Y and the notions of sufficient help would require a very complex formula. I apologize for that. Once individuated and defined those 6 levels of intensity of rights, it is useful to propose some examples of each degree. Using a tie seems a right of intensity 1. It is permitted behavior, but not especially protected by the law. To make a contract belongs to intensity 2. It is expressly permitted, but a new norm could forbid certain kinds of or modalities of contracting. When a citizen is suspected in a criminal investigation, he may ask the judge to be exempted from detention. This is to say, the right not to be arrested during the trial. If the judge grants that guarantee, and unless it is cancelled, the police cannot arrest the suspected subject within the frame of such investigation. If it does so, it disobeys the legal decision. However, this does not imply that the police have lost its general capacity of arresting people, neither that the detention of the citizen bearer of this right would be considered as an illegal abduction. So the exemption from arrest could be considered as a right of third intensity. The Constitution says that a citizen can publish her ideas without any censorship. This means that no state department has the authority or competence to prevent anyone from publishing something. A norm forbidding a publication would not become a part of the legal system. Of course, this does not imply that a citizen can tell a newspaper to print her ideas. Each editor is free to decide what is to be or not to be published in her newspaper. Thus, in some cases, as a practical matter, a citizen could not publish her ideas unless she does it personally. This way, the freedom of press seems a right of fourth intensity. Citizens have the right, and in certain countries, the duty, to vote. Of course, no State Department has an authority to hinder such action. If it does it, it would break the law. But this prohibition concerns particular persons too. Anyone who prevents a citizen from voting by any action tending to that purpose would break the law too. This contributes to make voting a right of intensity 5. Finally, an example of sixth intensity can be found in the right to education. Attending school is not forbidden, but expressly permitted. Any authority or any private person trying to keep a child from attending a school would act illegally. However, the guarantee goes further. Parents have the duty to have their children educated, but to fulfill such responsibility requires an external help by schools or similar institutions. Consequently, the system of education, ultimately a state responsibility, is as a whole obliged to provide facilities for the education of children. It has to be noted that within this level of rights intensity, it is not necessary that everyone would be obliged to help, as in the case of the duty of assistance, where the omission in case of imminent danger of death would constitute the crime of abandonment, but that there is at least someone obliged to facilitate the exercise of this right by a person who cannot exercise it by herself. We are now in a position to examine the character of the rights called fundamental or human or constitutional, rights on which, as pointed out at the beginning of the exposition, the legal reasoning of our time is based. If most traditional rights are considered, it is easy to state that the right to hear music is of level 1, the right to work or engage in illicit industry as the second degree, not to be punished without a legal decision is the third level right, the right to freedom of speech as the fourth degree, not to be enslaved is fifth level, together with the right to a healthy environment, and the right to be defended by a lawyer, at least when one has been charged with a serious crime, falls within the sixth degree. That way, the operative intensity of rights does not necessarily coincide with the relative hierarchy of the legal norms by which rights are established, neither with their moral or political hierarchy. Normative hierarchy keeps some influence in intensity 4 and in a lesser degree in intensities 3 and 2, as the guarantee of a granted right depends on the relation between superior and inferior norms. But in other aspects, those three hierarchies are different and independent. The moral or political level we assign a right is one thing. The hierarchical level of the rules granting different rights is another thing. Levels or degrees of intensity as proposed here are a third thing, independent from the former two. This reflection acquires a special importance when considered within the frame of legal principles, as mentioned before. If in a single legal decision, a judge has to apply the general principles according to their political or moral hierarchy, a comparative appreciation implicit in the so misleading idea of weighing rights and principles, the decision will determine the level of protection to be assigned to the invoked right, more or less independently of legal texts. In fact, any decision, even if conceived for a single individual claim, necessarily applies a general criterion to be used to decide any other case which is deemed similar enough in relevant characteristics. An example of this delegation and of the difficulties it carries along is the right to a decent housing. Explicitly established in many constitutions, such right is not guaranteed by a system allowing each citizen to get its satisfaction. It merely encourages political actions which very partially and depending on budgetary resources or general politics promote the construction of houses accessible to less favored citizens. The right so is operative within the positive system with intensity too. When it is invoked in a concrete case to justify the occupation of another's building or to claim a decent housing from the state, it becomes projected to intensity 6. If a judge accepts the claim, she is not only solving the individual case, she is proposing a general criterion applicable to a class of cases to which the present one belongs. Of course, different judges may apply different criteria, but this fact is just an example of how the legal system is diversified as legal interpretation reaches higher hierarchies of the normative system. My aim is not to maintain or to change the present priorities, nor to deny the importance of rights or encourage courts to ignore them. My purpose is to show the operative power of rights compared with the different emphasis they are attributed to within the political discourse, deeply received in the legal field. To declare rights belongs to political ideology, but to establish obligations, able to put them into practice, is a necessary task of the law. When a right is proclaimed, it is rare to precise explicitly the level of intensity with which it is guaranteed, when at the same time the power to determine such intensity in individual cases is given to the courts. Diverse possible criteria are open, and they may limit the scope of rights or to order their satisfaction in a way which, if generalized, can become very difficult or controversial. The analysis of the levels exposed now may be, I think, a useful tool to understand such difficulty better. Спасибо.